Ms. Zorba? Good morning.
Good morning. Carla Zarbo with the Attorney General's Fair Labor Division, and with me is Kate Fitzpatrick, also with the Fair Labor Division. This appeal essentially concerns a statutory interpretation, particularly Section 44A 2D. It's a part of the public construction bidding laws in the Commonwealth. It's a very broadly worded statute.
Well, it's actually not that broad, is it? It's construction versus a lease. What's broad about that?
The issue involved is construction versus lease, but the statutory language is actually quite broad. Every contract for the construction, reconstruction, installation, demolition, maintenance, or repair of any building by a public agency shall be awarded to the lowest responsible eligible bidder.
So why is this a contract for construction?
The RFP, the request for proposals that UMass Lowell submitted that they put out there actually calls for the construction of a dormitory for use for the public school.
So I take it a existing building would not qualify.
No, actually, this, as I said, the statute is very broadly worded. It includes not just construction.
That's the legal conclusion, right? You start with the legal conclusion. The question is the language doesn't include lease.
That's true.
So we have to find, I think the appeals court did, that it was somehow implied, implicit. I mean, this doesn't cover a lease, correct?
It does not specifically cover a lease, but it uses the term every. And it applies.
Every construction contract. It doesn't cover a lease.
It actually doesn't say construction contract. It says every contract for construction. And in the data troll case, this court ruled that a contract includes a lease. A lease is a type of contract. Leases are not excluded from this statute.
Lease is a contract.
So any lease that requires some construction is a construction contract?
Not every single lease that calls for construction.
Why not, under your interpretation?
Well, it depends on the degree. For example, in some of the examples that the Attorney General has attached as the addendum to our brief, we have some longstanding interpretations, not just by the Attorney General's office, but by our predecessor, the Department of Labor and Industries. They've made determinations, and our office has made determinations about when it qualifies as construction.
How much?
How much? If it's build out, if it's something that another tenant could easily come in at the end.
Like a courtroom or jail cells or something like that?
That would be more something that would not be easily converted, but something that's like retail
that would be
space.
that
would be construction as opposed to a lease.
So a lease for a courthouse facility for 5 or 10 years that would require certain build-out to specifications so a court could operate, that would be a construction contract rather than a lease?
Well, not in every instance. For example, in that Town of Hadley case that we attached to the addendum, in that case, the Attorney General's office determined that that was a lease. It was for a very short duration. It was for a period of 5 years while the courthouse, the permanent courthouse, was actually being built elsewhere. This was intended just as temporary office space.
I understand that, but I think Justice Cordy's, the import of Justice Cordy's question is the following. The state can lease buildings, correct? Public entities can lease buildings.
Absolutely.
And some public entities have quite specific requirements, correct?
Absolutely.
So you might have an existing building that a public entity wishes to lease, and the public entity, the very good public reasons perhaps, the public entity doesn't have the money to construct, and the lessor says, I'm happy for you to lease, and sometimes it's a law firm and they change it, and sometimes it's a jail cell. Pretty specific, correct?
It could be.
Well, I can assure you most landlords don't know as much about the requirements of a prison than prison authorities do. So it might be very specific. Doors have got to open left to right, doors have got to be able to, and so on and so forth. Do all of those become construction projects subject to the public bidding laws?
Not all of them. It would depend on the facts and circumstances. In fact,
what is the test that you are asking us to apply here?
Right. The Attorney General's office applies what we call a totality of the circumstances test, where we look at what is the primary purpose of the contract. Is the contract primarily call for construction? Who's going to maintain the property for long-term use? Is it going to be intended for long-term public use? What are the intentions of the public awarding authority? Were public funds used directly or indirectly in order to cover those construction costs? And
So as far as I could see, you want a two-part test: long-term needs,
Well, the length of the duration is certainly a factor that would be relevant. If it was something that was of a very short duration, like the Town of Hadley case.
Therefore, do you think is going to agree to undertake, all the kinds of substantial changes that are needed for, let's say, a prison or something like that, if it's only going to be a one-year lease?
It's probably not going to be, if it's an actual public use for a long-term operation, and if there are substantial changes that need to be made to the structure, either building something from scratch or modifications to something existing, then it's going to most likely be a construction
So what's
contract.
long-term?
Well, it could vary. In this case, I would suggest that the facts in this case dictate that it would qualify. We're talking about
So
Three five-year renewable terms.
a maximum of 30 years. So
Maximum, could be 30 years, if the state chose to continue to lease it because it found it continued to need the resource.
That's correct. The lease could be extended up to 30 years. There is even the potential it could continue after that. It could
Right,
be
well, so
extended
if it's a
beyond that.
5-year lease, though, with the state having the option to renew for another, 5-year terms, that would make it a long-term lease such that it would be a construction contract if there were construction involved?
No, it would depend on what's the overall intent and purpose. Like in the case of the 5-year lease for the temporary court
It seemed to
facility.
me that the overall intent and purpose here was that the University of Massachusetts didn't want to own another building. They wanted to lease.
Didn't want to have the risk of owning another building?
Well, their
Put the money
goal, their stated goal in the record, in the RFP and in the lease documents, their stated goal was to expand their housing available to their student population.
Sure.
They were in,
And there's no question that they can do that by leasing properties, correct?
They can lease property, but in these circumstances, under the way that they're proposing to do it, it would actually fall under the public construction bidding laws. They would have to follow the procedure put in place by the
But they don't
legislature.
want to own this building, and maybe after 15 years they want to do a whole different approach. So this gives them tremendous flexibility. They don't own this building for the next 100 years.
Owning is different than constructing.
Right. That's actually the distinction in this particular statute. It's very broadly worded. It's not just every contract. It's of any building by a public agency. And we've noted in our brief that it's interesting when you look at the historical origin of this particular statute. In 1967, a word was actually deleted from the statute. It previously read that maintenance repair of any public building. That word public was removed from the statute in 1967. The implication being that the legislature intended this to be very broadly applied, not just to buildings owned by the awarding authority or the public agency.
Two or three of the buildings, two or three of the responses in this case came from owners of existing buildings who were willing to modify their buildings. If one of them had been awarded the contract, would that have provoked the same response from the Attorney General?
If we received a notice of a bid protest, we conduct an investigation, most likely we would have the same result, that this was something that should have been put out to bid under the competitive bid procedures.
And that's because of the length of the lease. That's because of the measure of control. What are the key factors here, and how is an agency to know going into this?
Right. It would be all of those things you just mentioned: the length of the lease term, the public use of the building.
Of course, there's going to be a public use of the building.
It's the measure of oversight of the construction is pretty important, isn't it?
Absolutely.
And the specifications.
The specifications, the degree of supervision and control.
Yeah, but it's not uncommon, is it, for an agency to rent space in a building that has a cement floor and a cement ceiling, and maybe 10 or 15,000 square feet of space, and they need a conference room, they need a library, they need a reception area, they need offices and certain other kinds of rooms.
Has to be handicapped accessible.
Yeah.
There are lots of requirements for state operations.
And the architectural drawings are prepared, so the new carpeting is put in, new movable walls are put in, temporary walls are put in, new electrical specifications are met. Does that result in the application of Chapter 149?
Not necessarily. The facts here, like in Andrews versus City of Springfield, the facts here are that the specifications were very detailed. For example,
Keep
vending.
saying that. Can you understand what our concern is? Here's our concern. In any lease situation, when there's going to be any construction, there's closely supervised, because as Justice Spina suggested, the tenant wants to make sure that the conference room is not accessible by the public, or isn't, and so on and so forth. Is it the Attorney General's position that those are always subject to the public bidding laws? And if not, what is the limiting factor And you keep telling me the totality of circumstances. The totality of circumstances. That means every single public entity has to go to the Attorney General every time it is leasing any piece of property where there's going to be construction done as the tenant to make the space habitable by the tenant.
Well, they do have an obligation as a public awarding authority to ensure they are complying with the law, and they can come to the Attorney
So
General.
every lease where there's any construction where the specification is made by the tenant.
I don't think it would be that broad of an application of every single lease.
Tell me what the limiting principle is.
It would be a construction of such a degree, like it is here, like it was in Andrews versus City of Springfield, to such a degree that
What is such a degree?
so substantial.
So say, for example, you've got a medical examiner, or you've got a DNA testing lab, or you've got I mean, there are many public entities or pieces of public entities that do things for the public that are really quite specific, and they have to be very specific in terms of what their needs are if they're going to be a tenant. Is it your position that all of those are subject to the public bidding laws?
If it's of such a substantial degree that they're controlling the construction process, then under
What
the
do you mean
statutory...
controlling the construction process? They were not hiring the subcontractors. They were not there pouring the cement. They were very specific in their design needs, correct?
Absolutely.
And beyond that?
Beyond that, beyond just the design, they want vending machines that are the same type as the rest used throughout the UMass Lowell system, an architectural scheme that is...
Yes, that's a design. That's design. I'm very specific in my design. When the Supreme Judicial Court moved into 1 Beacon Street, we were very specific in our design requirements. 1 Beacon Street is a tall office building right next door here. Are you telling me that that is subject to the public bidding laws?
It would depend on the circumstances. If the degree of control is such that you're performing construction, that it's not incidental, that it's not something that a commercial tenant, a commercial landlord would normally do for the commercial tenant.
Do they have to does the public entity have to supervise the construction, or does it have to merely supervise the design before 149 kicks in?
Well, the statute itself informs that it applies when there is a building by a public agency. And in interpreting that word, by a public agency, in another context, this court in the Commonwealth versus Helms case said that...
No, my question is, the public entity can dictate 100% of the design requirements and have nothing to do with the construction, how it's actually carried out. In those circumstances, does Chapter 149 apply?
I would say it potentially could if they're acting as a project manager, if they're so involved in the design, they're involved in the progress of the implementation.
Now you may have given me some help. Project manager has a defined term in the construction industry, more or less, give or take. So are you suggesting that where the public entity is acting as the project manager, that would be when a lease turns into a construction project?
It would certainly be broad enough, or the project would be expansive enough that it would involve construction within the meaning of the statute.
In this particular case, there is a provision about supervising the construction, because there was some concern about Brasi's capacity to build this kind of structure, right? Was that going to be done by the Commonwealth, or was it going to be done by another firm?
Right. They were actually going to reserve the right to retain their own expert, someone
Were
to...
they in that sentence?
I'm sorry?
UMass Lowell?
UMass Lowell. They were actually reserving to themselves the right to retain very close supervision over every step of the construction process. They were reserving to themselves the right to attend all construction progress meetings, to be involved in every step in the process along the way.
Mr. Zorbo, just as a matter of background, why do we have public bidding laws? What's the policy? And why would you say that should apply here.
Right. The policy behind it, and actually in Massachusetts, I would suggest that we have probably the most comprehensive public competitive bidding laws in the country. Our purpose of having these laws is to promote a level playing field, so all bidders have an equal opportunity to engage in public construction,
Isn't
to
it
promote
also
fairness, integrity of the process.
Isn't it also so that, as the Ward Commission found, when some fly-by-night contractor gets a ton of money and puts up a building that then falls down again, or, you know, the ceilings start leaking and the flashing doesn't do it and the ceiling isn't and the roof isn't appropriate for New England, it's really to protect, in addition to making it fair, it's to make sure that when public funds are used to construct the building, we get a building that actually works for the public.
Absolutely. In fact, it became about as a result of the Ward Commission report.
So why isn't the Commonwealth perfectly protected when it's a lease where the landlord bears all of the risk of that, and the tenant can walk away from the building at any time for shoddy construction or any of these issues?
It's harder to move everybody out it would be better to build it well the first time.
And the reason that we have these construction bidding laws, these specific detailed requirements, is to protect the public use of these buildings. We have pre-qualification of contractors, pre-qualification of subcontractors, identification of some subcontractors. They have to be certified by the Division of Capital Asset Management. In this case, the contractor that Brasi would be using, it's actually another entity owned by an owner, a principal of Brasi. They would be operating without any DCAM certification. There's no balances in place.
Doesn't DCAM oversee the leasing by state agencies of buildings?
They do.
They do, actually.
They do.
The DCAM has to sign off on the leases. And the Inspector General has the power to investigate leases and fraud, collusion, all of that in leases, right?
Absolutely. In fact, the Inspector General joined with us in the amicus brief that we submitted in Andrews versus City of Springfield. They've actually adopted the same position on this issue that we have.
Thank you, Ms. Sorba.
Thank you.
Mr. Sansucci?
Thank you, Your Honor. Good morning, Your Honors. My name is Andre Sansucci, representing Brasi Development Corporation. The issue before the court is whether the competitive bidding statutes that govern construction of a building by a public agency apply where a private developer will build a building, assume all risk of ownership, and lease that building to a public entity, in this case, UMass.
Isn't this just a very sophisticated way of getting around the public building laws?
It's a way of complying with the public bidding laws because literally the statute does not apply. This is not construction by a public agency. It is a construction by Brasi. Brasi will own the building. Brasi will assume all risk of ownership. If the building deteriorates or is damaged by natural causes or otherwise, it's Brasi's risk. If after 15 years or less, UMass decides that they no longer need to have dorm space and they're not going to rent the space anymore, it's Brasi's risk and it's Brasi's burden of having a building that needs to
Can I
be
ask you a question about
revised.
that? As I understood it, the planning board, the Lowell Planning Board, had as a condition precedent of giving you the special permit that there be a 30-year lease. And this lease could be construed as a 30-year lease because it's got these renewal terms. What's the interaction between that condition of the special permit and, as you say, let's say after 20 years, Lowell says, we're not interested anymore?
Well, I think there's two answers to that. One is the lease itself and the RFP only contemplate a 15-year lease. After 15
Yes, but
years,
the reason
it's
that you got the permit to build was, as a condition, you had to have a 30-year lease, didn't you?
Well, that was for a prior project, Your Honor. And in fact, what that points out is that in order for this project to go forward as it is now structured as a 15-year lease, they'd have to go back to the planning board and get it approved. The approval that they got actually doesn't go far enough because it required a 30-year lease, and this is not a 30-year lease. The key thing about the length of the lease, I think, is to go to the question of whether this is a true lease. There's a distinction in the case law between true leases and basically a purchase agreement that is structured as a lease. And in Andrews, it was essentially structured as a lease, but there was an option to buy the building for $1 at the end of the lease. There's nothing like that here. This is pure, true lease. It's a lease of a building, they're paying rent, and they're getting
So
the right
that-
to use the premises.
So ownership is the controlling factor?
Ownership is a key factor because,
Where does it say that in the statute?
well, it says construction by a public agency, so the only, and literally the facts are that Brasi is building the building. And in order to get around that,
But doesn't UMass Lowell have significant control over precisely how the building is constructed?
well, they supplied some specifications, that's
Well,
true.
but it's beyond that. There's involvement. Isn't there active involvement in proceeding from one step to the next in the construction process?
Well, they do have some oversight, that's true, but the fact that they have some control over the specifications does not make it their building and does not make it their risk that the building will, if problems develop with the building, or even more practically, just if after 15 years UMass Lowell moves.
Yeah, but it doesn't make it a public construction contract.
No, because the risk remains on Brasi. And,
Where does the statute say that risk is the determining factor?
well, it says construction by a public agency, and literally, this is not construction by a public agency because it's not being constructed by a public agency, it's being constructed by Brasi. And in order
In
to
some sense, no building is ever constructed by a public agency. They're always paying somebody else to do the building.
But if they own the building, then then ultimately it's their building, and it is something that they constructed.
And I take it if the Commonwealth is paying the contractors, which they wouldn't be in this case, that would be another indicator that they were constructing the building.
That's correct. It's essentially their project.
Paying the contractors here.
Right. It's Brasi's problem.
Mr. Sansusi, are you suggesting that, contrary to some of the language in some of our earlier cases, that you could have really two things going on: very, very close supervision of the leased premises and a lengthy lease, and provided that you didn't get this option to purchase at the end for essentially de minimis dollars, or a right of first refusal, or any of those, that you leased? So we focus, from your point of view, on the true lease versus a purchase agreement.
That's correct, but I think there's also the length of the lease is important. In some cases, when you're dealing with equipment, if you have a 5-year lease, that may be in fact the life of the equipment. If you buy computers and you have a 5-year lease in which you're paying out payments and essentially you're paying the full value of the equipment over those 5 years, it's easier to call that a purchase agreement as opposed to a lease, even if it's.
So for tax purposes, when can this building be fully depreciated?
I
30
wouldn't even
years?
come close to trying to answer a tax question, Your Honor. But
isn't that an essential part of this whole formula?
well, I think that's the question of the length of the building or the
Isn't
useful
it
life
30
of the building, I think, is
But isn't it
important.
30 years?
Oh, I think it's reasonable to assume that the useful life of the building will be longer than 30 years, and certainly longer than 15. And that's the point, is that in a true lease situation, the lease does not cover the full useful life of the building, and the price does not reflects the rental value of the building, as opposed to being essentially a way to finance the purchase of it. The thing about Andrews was that essentially the payments made in the lease furnished a way to pay for the building and to buy the building. The other thing that has to be noted about Andrews that's very important is it was construction of a kennel. Presumably this building could only be used as a kennel once it was finished. Here we're dealing with specifications that, give some details as to how they want the rooms to be made.
Are you telling me that that's another test? Let me tell you why. Because prisons can only be used as prisons, but if you have a shell of a building, it can often be used for some other reason. Somebody's going to have to pay for taking out the holding cells and so on. But somebody could own a building, agree to modify it to become a prison sheriff or whoever it is moves the prison out, and the owner reconfigures it for something else. We do that all the time.
Sure. And in that situation,
So why are you saying that it could only be used as an animal shelter?
well, I think that the point you make may mean that Andrews, by the appeals court, is wrongly decided, because in fact, if the building could have been easily converted into another use, then
Was there a finding that it could not be converted?
no, I just inferred from the decision.
see that in
No,
the
there isn't anything in the decision that
What the
says that.
decision says, it gives me 4 factors which are very close to any tenant. I'm looking at page 683 of the opinion. any tenant would want to specify very carefully, want the conference here, want the door to open this way, whatever it is. And then it goes on to say further, it had the opportunity ultimately to acquire, and it seemed to me that you were arguing before that that's what distinguishes this from excluding.
But I think that's the most important distinction, is the option to purchase, particularly option to purchase for $1, because what that means is that you're in effect using the lease as a method to finance the purchase of the building, which is not the case here. And that's the fundamental distinction between the two cases.
Now, when can the city of Lowell walk away from this contract? 15 years?
15
or can
years.
they walk away earlier if there's any shoddy construction?
Well, they could terminate the lease if there's a problem.
The city of Lowell or the
Well,
university?
Okay, if there's
UMass
a
Lowell.
problem being,
The lease provision says that the obligation to repair defects is on the lessor, and a breach of that provision would be a default on the lease, and therefore that would allow UMass Lowell to walk away.
What about intentional destruction by one of the occupants? Whose responsibility is that? Student dormitory.
I'm not sure if there's a specific provision in the lease on that point. There may be something that says that that deals with that issue. I don't recall.
I take it the landlord has to insure this building.
That's correct.
For general liability purposes.
That's right.
And if there was an accident in the building, presumably you wouldn't be able to claim any form of immunity, anything of that sort, right? You wouldn't be able to claim any form of immunity.
Oh, Brasi would not have
No,
immunity.
right.
That's correct. As opposed to a
state,
unit
if they owned the
would have the $100,000 cap. That's
now,
correct.
if this section does not apply, which bid laws do? Do any bid laws apply?
UMass Lowell took the position that they had the authority to do this under Chapter 75, Section 1. It could be that Chapter 30B applies, the general procurement law. The Attorney General has never suggested that if the public bidding laws of 149 do not apply, this process was somehow invalid anyway, that we violated something else. So the focus of this case has been on 149.
Okay.
Yeah, 149 doesn't apply to actually a number of agencies, a number of public authorities.
That's true.
The UMass isn't unique in this regard,
Well, that's right.
in terms of having its own laws under which it both constructs and leases buildings.
That's true.
But now I take it that in all state agency leases, DCAM, Department of Capital Asset Management, is the agent and has to oversee and sign off on the leases. That's not the case with University of Massachusetts?
I don't know the answer to that, Your Honor. I don't know. But there is a extensive process in the RFP to protect UMass's interest in this. They had two committees looking at the proposals, and they had criteria to evaluate the proposals to see that, and they decided that this was in UMass's interest to accept this proposal as opposed to others that were proposed. And another thing that should be pointed out is that some of these proposals dealt with existing buildings. So one of the uncertainties created by the Attorney General's test is that you wouldn't know before you started whether the statute applied, because if it was an existing building that didn't need to be refurnished or remodeled, then the statute wouldn't apply to that proposal, but it would apply potentially to other proposals.
But it's a statute about construction, so, I mean, that's not so surprising, is it?
Well, perhaps not, but it's the point is that it's, if you look at the statute, it says construction by a public agency, and in this case, it was the RFP is intended to be a lease rather than construction by a public agency. And that, I think, has practical implications because it is easier for a public entity to lease premises and obtain the money to do that rather than having to enter into a long-term capital project to
I think one of the issues is you wanted this dormitory in operation in a very short period of time, or needed it to be operated.
Well, they wanted it as soon as possible. August 1st, 2009 was the goal. Obviously, that hasn't been met, but they wanted it as soon as possible, and that this was a way of doing it faster.
And we know that construction under the state construction can take 5, 10 years to go through the design process, the bidding process, and the construction process. So I take it that's another flexibility factor.
I think that's correct, yes.
Now, do I take you to be saying that a lease indeed could be within Section 44A2D if the lease is for the lifespan of the building, or if the lease includes an option to buy?
Well, I'm suggesting that at least a lease is not subject to the statute if it does not have those criteria.
Okay, but that's not the question I'm asking you.
Well, I understand that, but my
saying,
point is
are you
that
saying that indeed this statute may cover a lease under certain circumstances?
It's conceivable that it would. For this case, you don't have to decide that question. Andrews, you would have to decide that question specifically because they're dealing there with a lease that did have an option to purchase. But for the purpose of this case, for Brasi, we simply didn't have that.
Well, you say that, but if you can't answer the question of Justice Spina as to what is the depreciation that your client is giving for this building, how can you say that 30 years is not the lifespan of this building as far as Brasi is concerned? I mean, if Brasi is writing off after 30 years, that's the lifespan of the building that Brasi is telling the IRS.
But I don't think tax considerations, Your Honor, should be the controlling factor as to the length of
But
the
you've
building.
just asked me to distinguish between a true lease and not a lease, and one reason why that body of law has arisen is because of the tax consequences. That's where most of the case law arises. Correct?
I'm sorry, I didn't hear.
Well, I mean, you asked me to distinguish between a true lease and a purchase agreement, and one reason why that body of law has arisen is because of the tax consequences. Correct?
That may be. But in any event, it certainly doesn't I think you can look at the useful life of the building, because the useful life of the building is important, quite apart from tax consequences. When the lease is over, what happens to the building? Taking the computer equipment example, at the end of 5 years, the computer equipment is obsolete and gets thrown out. At the end of 15 or even 30 years, this building is still going to be used and still be useful. And it is for that reason
that may depend on the quality of construction.
Well, we intend for it to be that.
I know, but your client is not viewed by DCAM to be certified to do public buildings. So isn't there a concern as to the quality of construction?
Well, UMass undertook to determine whether Brasi was qualified. They had, in the response to the RFP, extensive information about the background of Brasi and the fact that the principals of Brasi and the development team had been involved in numerous projects.
The Ward Commission was concerned, though, about the use, about whatever relationships may exist. I'm not suggesting that there's any relationship here, but could there not be a more sinister situation in which you have a debarred contractor who is not suitable for work on public work, who is going to now be involved in building and then doing a long-term lease in order to evade the obligation to be a certified contractor? Isn't that a concern we have to consider?
Well, it's a concern, but again, the risk would be on the lessor in that situation, and the lease provides an out for the lessee if it turns out that the building is not done properly. So there is some risk, but the risk is primarily on the lessor because
that's a sort of inadequate solution, isn't it? I mean, if you've got 800 students living in a building, you say in the middle of February, whoops, got to move everybody. I mean, you'd want it to be built well the first time, wouldn't you?
Certainly, and UMass took steps to ensure that that would happen. Their process was objective and fair. They had 2 committees looking at the proposals. They made sure that the proposed bids were substantial and that the bid was awarded to Brasi after concluding that it was more qualified to build a quality building than the other proposals that were available. So,
But I think Justice Gantz's point is, and I will assume all that is correct, that the way that you would read 44AD2 or is to say that wouldn't be a condition precedent to doing this. If it's a lease, it's a lease, and quality of construction doesn't matter.
well, DCAM certification would not apply under our interpretation of the statute. That's correct.
But I take it that may have been one of the reasons why there were so many specific specifications that you had to meet in order to qualify, and presumably the UMass
But the
wouldn't
UMass
become a tenant unless you met all of the very detailed specifications that were set out in the lease.
That's correct, and that's why it was a way of protecting their position and making sure that they got a quality building, which we're confident that they would have if this were completed. So,
Thank you, Mr. Sansucci.
thank you, Your Honor.
Before counsel leave, and I address this to both counsel, I have here a brief from the Attorney General and I have here a brief from a leading law firm. Some years ago, the Justices of the Supreme Judicial Court amended Rule 16 to require that there be a certification signed by the attorney that the brief complied in all respects with that. I have a certification from both attorneys. Your briefs do not comply. The Attorney General's brief, to my knowledge, doesn't contain any of the statutes on which it relies, and your brief does not contain the decision from which you are seeking relief. I would ask that in both cases, and to all counsel who are represented here, to consider the certification under Rule 16K as serious as a certification of service on the other parties. Thank you.